have no doubt that following Netflix's release of the Squid Game series, there'll be many questions raised as to whether or not anything depicted in the series could possibly amount to anything lawful under English law, or any other jurisdiction for that matter. And what we're really talking about is whether or not participants can consent to serious or lethal bodily harm when partaking in a game of some kind, or whether that amounts to any kind of defence for anyone inflicting such harm. Those are the kind of questions I'm talking about today. But first of all, if you're new to me, I'm a barrister who helps you understand law on this channel, so please hit the like button and subscribe and hit the bell icon so you don't miss out on future videos. So as usual, there is a short answer to most of these questions and a much more lengthy explanation and discussion with many more complex questions raised, some of which are yet to be addressed by the courts. But nonetheless, I will pose some of those questions here for discussion and thought. And I'm going to say right at the outset of this video that this is not intended to give anybody watching any excuse whatsoever to go out and cause harm to each other or to consent to partake in any kind of game that includes any risk of harm whatsoever. Unless, of course, it's an organised sport, in which case you have to take direction from those instructing you. But otherwise, with that disclaimer out of the way, on with the video. Starting out with the very basic form of battery, which is the unlawful application of force upon another person. And this, of course, includes the very simple act of touching somebody else without their permission. But of course, if one consents to that touching, then it doesn't amount to unlawful battery. But how far does that consent go? As I said, there is a simple answer to most of these questions, and that is that a person cannot consent to bodily harm or serious bodily harm, save for some narrow exceptions. The obvious one being medical intervention. Obviously, certain medical procedures involve some kind of harm, particularly surgeries where there are incisions to the skin, and therefore it would otherwise amount to serious harm. But this is obviously necessary in the context of medical intervention. Other obvious examples include tattooing, which strictly speaking is a wounding of the skin because it's penetrating the skin. Ear piercing, obviously this is a wounding of the skin which requires consent of the person involved. Even something as routine as a vaccination, because it involves penetration of the skin, you are required to consent, and nobody can forcibly inject you with anything without your consent. To do otherwise would amount to a criminal offence and grievous bodily harm, because you've not consented. The longer discussion and various questions posed include things such as sports, where people do consent to take part in the sport, knowing that they might get injured. But again, there are limits, and it very often comes down to the intention of the parties involved. For example, in one known case, there was a legal challenge to the amount of force used in a football tackle, which caused severe damage to the other player's ankle. The person doing the tackle argued that this was within the rules of the game and the intention was only in continuance of that game and nothing more. The court essentially agreed and said so long as the play was within the rules and the practice of the game and had not gone beyond those bounds, this was a firm indication that it was not a criminal act. But the court also said that even in very highly competitive sports, where in the heat of the moment conduct might go outside of what might be expected of the rules of the game or practice, it might still not reach the level of criminal liability. In short, it would depend on the degree of force used, the extent of the injury, and whether or not the act amounted to something malicious, not just unlawful. So how does this then apply to boxing, when the participants clearly enter the sport knowing that there is a serious risk of injury and even death? And this is not something merely academic. Of course, boxers have received multiple or single concussion blows that have resulted in death. So how does consent apply in such situations? Well, to that end, there was a Law Commission consultation paper numbered 134, written in 1994, that specifically addressed boxing at part of the paper. At paragraph 1019 of the paper, it acknowledges that boxing is something of a unique sport, and says that the intentional infliction of serious injury not only is something that is permitted within the rules, but in reality the essence of the sport. Boxing originally appears to have been regarded as lawful not through any application of principle or by reference to the legal rules applying to other sports, but simply because it was not for the prize fighting that it had been declared lawful, on grounds as much related to public order as the law of offences against the person. The paper goes on at 1020 to say the ultimate objective of every boxer is to knock his opponent out, conduct that almost inevitably involves the infliction of grievous bodily harm on the opponent, contrary to Section 18 of the Offences Against the Person Act 1861. This conduct is inherently hostile. So essentially the paper acknowledges that boxing is a seriously dangerous sport in which grievous bodily harm is an inevitable consequence and in fact part of the object of the sport. So how does that apply if two individuals want to consent to a fight to each other, whereby the object is to knock each other out? Well, this was something addressed by the Court of Appeal, which said that such consent could not found a defence to any criminal charge, and thus casual fighting was not a special category that took it out of the case of the general law as to consent. And as quoted in the paper, Lord Lane says, "It is not in the public interest that people should try to cause or should cause each other actual bodily harm for no good reason. Minor struggles are another matter, so in our judgment it is immaterial whether the act occurs in private or in public. It is an assault if actual bodily harm is intended and or caused. This means that most fights will be unlawful, regardless of consent." So what we're really saying is that casual or street fighting is not lawful, but fighting in a boxing sense is lawful, but is accepted to be something of a unique case. But that doesn't mean that two people can come together for some agreed fight, prize or victory or anything else, because that would be known as prize fighting, which is also unlawful. So how about then if we take this into a slightly different context and say that people are just playing around? Let's call it horseplay. And there's a very real risk of serious harm. Well, again, this comes down to the issue of consent. Did the parties consent to the horseplay knowing that there's a risk of harm involved? There are several such cases as this, one of which involved university students that had been out drinking and then whilst playing around thought it was funny to hold one of their fellow university students over a balcony. Unsurprisingly, he fell 10 or 12 feet and got seriously injured. The prosecution case was that the defendant's actions were unlawful and malicious. During the trial, the judge directed the jury to consider the appellant's intention based on that of a reasonable and sober person as to whether or not there was a likelihood of serious harm. And in doing so, they were convicted of inflicting grievous bodily harm. But on appeal, these convictions were rendered unsafe, because the direction should have been whether or not these particular appellants would have foreseen, had they not been drinking, that their actions might have led to injury. In another case, RAF officers were setting fire to each other's jackets as part of horseplay. Unsurprisingly, one of them got burnt and seriously hurt, and each of them were convicted. Although these convictions were quashed on appeal because there was discussion over whether or not the acts were unlawful or not, because each of them had consented to the horseplay and there wasn't the intent to cause harm. Then there is an area that we'll refer to as dangerous exhibitions. Think knife throwing and things of this nature, where a willing and consenting participant is standing against a board and hoping that the person has enough skill to miss them when throwing knives or something like that. This is an area of law that is essentially uncertain and untested, and I suspect that if cases like this come to court because someone has been seriously injured or died, then I suspect that the courts are going to be unforgiving and potentially curtail any kind of consent permitted in such situations. As an aside and a separate issue, many people might be asking about the defence of duress and whether that would apply in such situations as in the Squid Games. That being where the person feels that they are impelled to act because, as a result of what they reasonably believe someone else has said or done, they have good cause to fear death or serious injury. And secondly, whether a person of reasonable firmness, sharing those characteristics of that person, would have responded in the same way. However, duress is not going to assist in this situation either, because whilst duress is a defence to all other crimes, it does not include murder. Neither does it include a person charged with murder as a principal or as an aider, abettor, counsellor or procurer, although it may apply on a charge of conspiracy to murder. So essentially what you can take from all of this is that there are certain situations that you can consent to harm or even the risk of harm, but the limits on this are going to be very narrow, and they certainly aren't going to include anything where there is a certainty of serious harm or certainty of death. Neither could you rely on duress on the basis that someone else has said or done something that made you believe that you are going to suffer serious harm or death as a result if you don't act, because as I said, duress is not a defence available to murder. So ultimately my message to you is please don't go out and reenact any part of the Squid Games, even if you think you are limiting the amount or the infliction of harm caused, and whatever age you are. Whilst consent has been known in very limited situations to apply to horseplay and rough play and things of that nature, the courts, in my view, are going to take a very restrictive view on when consent applies and to what level of harm it would apply to. So in any case and any game and any level of harm, you are risking criminal prosecution if someone gets hurt, and consent, in my view, is going to be a very narrow exception, which more often than not is going to fail as a defense. So with that in mind, please remember to like the video, and remember, stay humble and subscribe.